like to introduce my friend Julian Gresser. Julian is an international attorney, a professional negotiator, an inventor, an author of several books, including his latest one, How the Leopard Changed Its Spots, which I believe will be published in May. He's an expert in international negotiations and was twice a Mitsubishi visiting professor at Harvard Law School and a visiting professor at MIT's program on science, technology, and society. He's the founder and president of Big Heart Technologies and the Broadband International Legal Action Network, which is our partner in producing this series of webinars. Please join me in welcoming Julian Gresser.
Thank you very much for the opportunity to discuss these very important issues. And I really commend Scott and Andrew, who for municipal lawyers who are listening today, they really have given you a very detailed and practical how-to protect the public and comply with the Telecommunications Act of 1996. What I'm going to do in my presentation is to try to step back a bit and offer a new perspective, a powerful resource to empower choice, which I call evolutionary values. And I'd like to say that we're in the midst of a great transition now. We have been under the last few years, maybe the last decade, in a situation where there's been increasing accretion of power by major industrial interests, which have had a effect on essentially co-opting federal and state decision-making. So we are faced with a choice at all levels between false narratives, contempt and defiance of law, and co-option of government. And so what I'm going to do today is offer some practical applications of what I'm calling evolutionary values in advocacy and negotiation, local ordinances, and litigation. So first, let's define evolutionary values. I define these as central, those values which are central to individual, community, and planetary survival. We're engaged, I believe, in a national, what you might say, planetary struggle over which values will prevail. And I believe our very survival may depend on the articulation of these values. Now, evolutionary values ask, those who propound them ask this question: does this decision affirm life, enhance happiness, reduce misery, expand compassion, allay fear, build trust, and promote greater balance? Often evolutionary values espouse a higher ordinate evolutionary goal. For example, in the case of the protection of local communities, the implementation of a balance between necessary economic development and environmental protection. And they see the big picture, which is to also include rights of nature, responsibilities to succeeding generation, and the protection of the most vulnerable. I believe this discussion of evolutionary values helps to crystallize and go right to the core issues. There's a great body of laws that embody life-affirming evolutionary values, although this is language that's not customarily used in very specific ways, both with regard to substantive rights as well as procedural obligations. For example, the National Environmental Policy Act, the California Environmental Quality Act, all clearly emphasize the priority of environmental considerations, including health. The Americans with Disabilities Act, the constitutional provisions about due process. Really, the case that we are discussing in terms of Los Angeles, if I refer to LA versus the Los Angeles County Board of Supervisors, is about the right of the people to be heard. This is an evolutionary value, that people matter in these decisions. Historical sites matter. The interests and concerns of the voiceless and defenseless, poor people, poor communities, economically disadvantaged and minority communities, children's rights, all of these matters. And also, in terms of evolutionary values, the law is very clear that there are administrative processes that affirm these values. Interagency consultation with other experts. This is what CEQA is requiring. substantial evidence rules, non-delegation of legislative authority as a bulwark against conclusionary, arbitrary, and capricious decision-making. All of these are checks. They're not just there by chance. They're checks to control and limit autocracy and despotism. So I'm suggesting, on top of what Scott and Andrew are suggesting, just like many laws have preambles, ordinances might have preambles. And these preambles convey both the meaning and spirit of an ordinance, and therefore they become a powerful guide to its interpretation and application. Example, an ordinance could have: the intent of this ordinance is to affirm and advance evolutionary values that recognize the fundamental rights of the public to be heard and to exercise informed consent. It's a critical idea on matters that deeply concern their personal health, property, and well-being. The protection of children, minorities, and those which lack the financial and legal means to defend themselves. Rebalance and allocate the risks and costs of public industrial hazards upon these entities so that they are imposing them away from the public that is being asked to bear them. I call this the public pays principle. Adopt affirmative and incorporate the precautionary alara, least available, most protective, available, reasonable alternative principles. Safeguard the environment and succeeding generations, and uphold truthfulness, fairness, and the integrity in science and public disclosure. I mean, when you think about it, that's what these fights are all about. And the explicit articulation of these values will go right to the core of what we're concerned about. I'm moving to the next and final slide, Doug. I'd like to point out that in our present case, in which Scott and I and Mitchell Tsai are litigating against the Los Angeles County Board of Supervisors, this case is also about evolutionary values. The art of public interest litigation, in my view, and as I see it as a lawyer, is to translate this large conceptual framework of evolutionary values into winnable legal principles and arguments. Now, the California Environmental Quality Act is very clear. This is the intent of the legislator to require responsible forbearance and precaution. Now, what the Los Angeles County and its planning department is doing is categorically ignoring this. It's basically saying we don't even have to pay attention to any of it. And the California Constitution and the US Constitution requires basic procedural due process and prohibitions against taking of property. That is not central to our case as we've pleaded it, but underlying, at least as it affects some communities, a very serious issue about the taking of private property without any compensation, much less notice. These are deep and profound issues. And as I said in the beginning, we're in a process of transition where I think the pendulum is moving back toward some reasonable balance. And I think if local municipal lawyers listen carefully to what Scott and Andrew are saying, and then are guided to some extent by what I'm saying, is we will find the right balance, a healthy balance, and moving further into this decade. Thank you very much.